Cameras on. Welcome to GrassRoot, Ohio. Conversations with everyday people working on important issues here in Columbus and all around Ohio. I'm Carolyn Harding, and today I'm talking with Bill Lyons and Terry Lodge, organizers and legal counsel for the Columbus Community Bill of Rights and the Ohio Community Rights Network, fighting to protect the water, air, soil, and rights of Columbus Metro and communities facing environmental, social, racial, and economic harms throughout Ohio. Bill Lyons is a mathematics and science teacher who has taught nearly 40 years on 4 different continents at the high school and college levels. He is an organizer, co-organizer of the Columbus Community Bill of Rights group, and he is president of the Ohio Community Rights Group. He has been an activist since 2015 when he got involved in the community rights and rights of nature movements because he is passionate about local democracy and social and environmental justice. Terry Lodge has 50 years experience as an activist and civil and environmental rights lawyer. As a field attorney for the Community Environmental Legal Defense Fund, or CELDEF, since 2014, he's worked to gain ballot access for grassroots initiatives proposing controversial local laws, such as the rights of nature and control of the commons. In court, he's opposed nuclear power and weapons, corporate welfare, mountaintop removal mining, fracking, and has supported free speech and diversity in the workplace. He's been recognized by the Alliance for Nuclear Accountability, has received an Access to Justice Award, and is a past Ohio Civil Liberties Union champion. On April 16, 2021, the Community Environmental Legal Defense Fund, or CELDEF, issued a press release stating, a lawsuit demanding the temporary suspension of a unique Columbus City Charter petition rule was dismissed by the U.S. District Court for Southern Ohio on April 14, 2021. Petitioners seeking to ban harms from the fracking industry within Ohio's capital city and surrounding watershed filed the lawsuit in June 2020, arguing a June 2020 deadline on signature gathering was unconstitutional during the COVID-19 pandemic and should be extended. The deadline effectively killed ballot access for the initiative, according to the lawsuit. The rule places a 1-year timeline on ballot initiative petition gathering. The group has met these requirements in the past, and had it not been for state shutdown orders, were in position to meet the deadline. So, in effect, the U.S. judge denied the Columbus Community Bill of Rights their right for direct democracy. Terry, as an attorney, can you give an ever so brief description of what direct democracy is?
Direct democracy is where the people get to propose actual laws that would have teeth in them, and they get to circulate petitions. They get to work very hard, in other words, to put things on the ballot and to wage a campaign that often is or can be opposed by major governmental or corporation interests. And they get, if they're fortunate and have dotted every I and crossed every T correctly, they are rewarded with the chance to persuade their fellow citizens, fellow voters, to pass something into law.
So citizen initiated ballot initiatives are direct democracy, correct?
Yes, and it's an unusual thing, not recognized in all states, but Ohio has since 1912 had an initiative and referendum amendment or section in the Ohio Constitution. It was seen as a response to increasingly corrupt governance, especially at the General Assembly level.
All right, so Ohio is one of the few states that has this home rule or direct democracy.
I think there are about 27 or 28.
Okay, great. Bill, can you please tell our listeners, break down what the Columbus Community Bill of Rights folks have done up to this date in, not too detailed, but to give them an update to where we are?
Okay, you mean starting from our very first campaign or just this last one?
Sure, but nice and brief.
Sure, sure. Well, we've been fighting for our local democratic right to protect our water, our air, our soil, our environment from harms, and specifically from the oil and gas industry and the fracking industry since 2014. So 2014 was our first ballot initiative that started in mid 2014. And we midway in that, well, actually early on, the city changed the rules. Back then, there was no time limit on how long you had to gather signatures. So they put a bunch of provisions because there was a committee created to look at amending the Columbus City Charter. And they proposed a bunch of amendments that they put on the ballot, and wrapped up in those, which a lot of people maybe weren't aware of, they decided to limit the ballot initiatives to 1 year. And so then the city council encouraged passage of that. So that got on the ballot in November and it was passed. So we started our campaign not having a time limit, but then part of the way through it, we only had 1 year. So we turned in our signatures. By the time they were validated, we had over 13,000 signatures, but we fell about 1,000 signatures short. And that was for a charter amendment to the Columbus City Charter. Then in March of 2016, we started again, and this time we were going for a charter ordinance. And we had a 1-year campaign, and we turned in our signatures in March of 2017. We collected over 11,000, and again, we fell about 1,000 signatures short. So our third attempt was our big one, well, most successful to a point. We started collecting signatures, and this was for an ordinance again in June of 2017. And we collected over 18,000 signatures and turned those in June of 2018. And we had we met the signature requirement by more than 3,000. So we were way over it. We met the requirements by the city council. The city attorney approved the language, the form of our initiative. The Columbus City Council, they voted to put our initiative on the ballot. And the Board of Elections met, and they decided to vote against our initiative appearing on the ballot, and citing a law that was put in place in 2017, which we feel is unconstitutional law, that gave boards of elections legislative authority to keep citizen initiatives, judicial authority to keep citizen initiatives off the ballot if they felt they were beyond municipal authority. So we've appealed that to the Supreme Court, and the Supreme Court, rather than rule on directly on that issue, they kind of went around it and ruled on used some other ruling against us. So then, encouraged by what happened in Toledo after the Lake Erie Bill of Rights got on the ballot and some changes that the Supreme Court did just a few weeks after using a ruling against us, they changed that. And then the Lake Erie Bill of Rights got on the ballot and was passed in 2019 in February. So we started again in June of 2019, and this time for a charter amendment again. We were almost 9 months into our campaign. We collected almost 9,000 signatures up until March of 2020 of last year, and we all know what happened. COVID hit. So we decided to suspend our signature gathering because there were lockdown orders, and then we felt like, how could we responsibly risk the health of our members and the general public by collecting in-person signatures? So we suspended our initiative at that time. And we then appealed to City Council to extend our time, since we only had this 1 year now to collect our signatures, and we still had 3 months left. And we didn't feel that it was responsible for us to continue collecting signatures. So they refused to extend our, to give us some relief from this. And so we were then we asked them to put it on the ballot then and let people vote, let them decide, because they voted to put our initiative on the ballot the previous time. Again, they refused. And so therefore we were left to sue this time. So.
Okay. So around a year ago, there was this, that Columbus Community Bill of Rights decided to sue the city of Columbus. Terry, can you break down this lawsuit and the decision in everyday people's language?
Yes. First of all, Bill's memory is impeccable, and his summary of the enormous work that goes into preparation, hitting the pavement, deciding what the wording of the petition should be. All of that is gobs and gobs, enormous, hundreds of hours of work, all of it volunteer, and all of it very conducted in a way that has to comply with some pretty stringent legal requirements. So what happened approximately this time last year? Yeah, there was an initiative in Dayton that that we weren't, no one in this discussion was affiliated with, but a lawsuit was brought by the citizen organization there based upon the fact that COVID was creating problems with their being able to organize because they couldn't get volunteers to go out and all that. And a federal judge briefly put into place an order that extended their time to petition. However, there was a urgent appeal taken to the Sixth Circuit, which canceled that trial court order. We nonetheless, in about June 17th or 18th, I can't remember the exact date last year, filed suit in the Columbus division of the Southern District of Ohio Federal Court. And the purpose was to seek essentially a day-for-day extension of time beyond the 1 year time limit, which would have run out about June 19th or June 20th, 2020. We first sought an emergency order suspending the 1 year provision. That's called a temporary restraining order. We had a hearing and argued it for about an hour and a half or two by Zoom. And the judge declined to issue a temporary restraining order. That still left the lawsuit pending. The case that I was talking about from Dayton was by this point in time pending before the U.S. Supreme Court because it would have, had it been decided in favor of the citizens, it would have probably dispensed with the need for us to proceed. We suspended action on the case with the court's approval on our case with the Columbus order. And it wasn't until months ago in March that we filed a response on behalf of the Columbus organization, and the judge ruled upon it in April, dismissing the lawsuit, finding that citizens did not have a right to extend the 1 year time limit. What was most frustrating was that when the DeWine administration, Dr. Acton, the public health director, was issuing the orders in the late winter and spring months of 2020 regarding the pandemic, they were requiring, they were shutting down businesses, they were, imposing enormous restrictions and shutting down public activities, gatherings that would normally be attractive for petitioning activity. And the citizens in the Columbus group, understandably, were very fearful for their personal health and safety, and were, I'm sure, going to have problems getting people to volunteer to turn out, because essentially all that was left was going to things like the reduced activity in downtown Columbus, and hitting up people on the sidewalk for petition signatures, or perhaps going to what few gatherings might be taking place at public offices, such as the unemployment agency. But even as that sort of thing was under contemplation, various governmental and private organizations were, making themselves very difficult to get personally in touch with or to have face-to-face meetings with. So the gatherings just evaporated. But the Dr. Atkins orders kept repeating, all of them have this one clause that First Amendment activity is not affected by these orders. And that turned out to be an escape hatch for the court to rely on, because the court insists in its ruling of April that because of the fact that First Amendment activity was not affected or shut down, restricted in any way by the health department orders, that the people had theoretical only right and opportunity to complete the petition campaign. Our case was made on the fact that you have to have thousands of excess signatures in order to ensure that you have enough to get on the ballot, as Bill cogently explained. So it's kind of an absurd decision, but it's the kind of thing that we've come to expect. The people's right, and it's interesting. What was going on also in April, May of 2020, the Ohio General Assembly passes on a very urgent basis all kinds of changes, temporary suspensions to normal laws, that they actually extended all statutes of limitation in Ohio court filings to at least the end of July 2020, which is astonishing, absolutely unprecedented. Because it was impossible other than to electronically file in the courts were basically put on hold in terms of people's rights, which were preserved. It became possible to, by remote application, renew driver's licenses, renew hunting and fishing licenses, renew professional certifications, that sort of thing. Things that had formerly required in-person appearances or submissions. But the people's right to initiative somehow didn't get extended in any way, and the Ohio General Assembly apparently did not take up the issue, nor did the City Council in Columbus. So
with that, let me do a quick station ID. This is Carolyn Harding with GrassRoot Ohio. I'm talking with Bill Lyons and Terry Lodge, discussing the Columbus Community Bill of Rights and the direct democracy that was denied by the courts. Bill, I'd like to know what are some of the arguments that the city gave to deny the right to be put on the ballot.
Okay, well, first of all, excuse me about that, that the city appeal, and they took their decision from the city attorney, Zach Klein. And he made the statement, and I'll quote, the city attorney's office reviewed your request to extend the petition signature timeframe and determined that neither the mayor nor council have the power to override the charter even during an emergency. I wrote back to them because in the city charter, there is something called emergency measures. And the emergency measures states the council may, by a vote of 6 of its members, pass emergency measures to take effect at the time indicated therein. An emergency measure is an ordinance, a resolution for the immediate preservation of the public peace, property, health, or safety. And there's more to it, but that's the part that applies, I think, to us. So I wrote back and I said, certainly with a pandemic and the act of collecting signatures, that should qualify for public emergency to preserve health and safety. And they could invoke that measure and they could suspend all signature gathering for campaigns that were going on. And then once it's deemed safe, allow them to pick up where they left off, and thereby still have a total of 1 year to collect their signatures, but just have a period in between where it's just too dangerous to suspend it. They never responded to my request for that. So that was the first part. Then they said that when we asked them then to put it on the ballot, because then they refused to extend our time, they were saying that, well, they can't do that. It would be unprecedented to take a citizen initiative and put it on the ballot. Well, they agreed that our initiative in the third campaign should go on the ballot, first of all. Secondly, they get their ideas about things that should go on the ballot from all kinds of different sources. So the fact that we had something that came from the people, they also have the ability to put anything they want on the ballot. So that was a bogus argument there. So that's my answer to that.
Terry, you chose to deal with one issue, that of the time lost due to the COVID shutdown in this lawsuit. Why?
I'm sorry, I don't understand your question.
Well, the focus of this lawsuit
Right.
was about the time
Right.
that was lost,
Yes.
or making up the time.
Yes.
Why did you choose such a narrow focus?
Because because we, number one, the group voluntarily, after the pandemic order started coming down, the group suspended its activity. All of us were hoping, and we were being told inconsistent things by federal and state governmental leaders as to how long the lockdown might continue. There was some hope persisting in April and May and early June that maybe things would actually loosen up because the summer was coming and the virus is less spreadable during summer months, that kind of thing. And so the group was hoping that, if they could salvage just a few weeks before the year ran out, that it wouldn't be necessary to file suit. We ended up filing suit because it was straightforward, because the issue was and still in my mind is very clear cut. It is grossly unfair and unfortunate, and no one's fault that there was a pandemic. But as I say, with the General Assembly creating and waiving and creating bypasses and time extensions for all manner of very important public and private affairs and matters, it was certainly inconsistent for one of the most important democratic rights to not be treated in the same fashion. Notably, the city's posture in this was as though there would be opposition, like there were two sides to the issue of extending time. Since initiative is the people's right, and yes, while it could theoretically have been that someone might object and try to sue, whoever from the public or from the corporate sector, whoever might have opposed the Columbus Bill of Rights proposal would have to wait until the petitions had been circulated, signatures gathered, and the matters before the Board of Elections and or ultimately the courts. That's why the courts are there, to sort things out. It's not for the politicians on city council or the political acts of a mayor and his or her administration to basically shut down a citizen initiative campaign.
So Terry, can you tell us your estimation of the judge's final say, the U.S. court judge? Do you think that their legal justification is right? Is it logical, or
No.
did they really miss the point?
Well, it is problematic on a wider scale than simply whether or not the courts have the power to extend citizen initiative petitioning. The Sixth Circuit Court of Appeals, the Intermediate Court of Appeals here that operates federally over Tennessee, Kentucky, Ohio, and Michigan, has held several times that state management of initiative is kind of a secondary matter that is left up to the states, who may have arguments of efficiency or election economy, that basically whatever the states think is proper, and by states I would say the General Assembly and city councils when you're talking about local election initiative management. But basically the holding has been in recent years that essentially whatever the states want to do is fine, the federal courts aren't going to step in. And that's a real serious problem, because there is a line of constitutional precedent going back to the early 1980s that says that petitioning and initiative participation, if you will, participation in putting something on the ballot and campaigning and voting for it, is First Amendment protected speech, because you're associating with people. One of the clauses in the First Amendment is the right not just to free speech, but to petition the government for redress of grievances. And that's exactly what this is. Yet the federal courts are backing away, not just in the Sixth Circuit, but certainly in Ohio and the Sixth Circuit states, Michigan in particular, backing away. They're not protecting the initiative right. It's very troubling. It unfortunately seems to be in the same tone and handled in the same manner, these pronouncements, as the Ohio Supreme Court, which, as Bill pointed out, keeps finding these whack-a-mole ways of ducking the issue of the citizens' apparent unfettered right to put whatever they wish on the ballot for a vote.
Okay, we have 1 minute left. Bill, how can people get more information?
Well, our website has information about this, which is columbusbillofrights.org. They can find that. Also, they can write to us at info. I think our address is info@columbusbillofrights.org. Yeah, so those are a couple ways that they can contact us.
They can reach folks also through Ohio Community Rights Network as
Oh,
well.
yeah, well, Ohio Community Rights Network, right? That's
and I have one more question. What's next? Can we take it to, can the citizens take it to another judge? Or is this over? Do we have to start over again?
It's over. We're not going to, in light of what happened to the Dayton case, we are not going to petition the U.S. Supreme Court.
Yeah.
So this particular round is over.
Yeah.
Okay. So what's next for the Columbus Community Bill of Rights? I mean, there still is injection wells putting toxic radioactive frack waste in the watershed of Columbus. So what do Columbus citizens do, Bill?
Well, first of all, look for us, because at some point we will probably have another ballot initiative. They can donate to our campaign and sign up for our newsletter to get updated information on the website as well. They can help us help write about the injustice of this. I mean, the more people we get on our side, the more we can fight this kind of hypocrisy. And
I understand that there are citizens every week at the Columbus City Council talking about how the City Council should support the Columbus Community Bill of Rights.
Yes, we're letting them know we have lots of supporters and lots of people who are upset about what happened here.
All right. Thank you so much for your legal advice, Terry. Thank you so much for your hard work, Bill, in leading the charge. And this issue is not done, even though the judge say we should give up. The pollution is still happening and folks are not going to have it. So we'll find new ways, won't we?
Yes, we will. Yes, we're not going to give up. It's too important.
All right. Any words of advice?
Well, I think that we've got to let people know to fight back, and keep the pressure. Terry?
We only lose when we quit.
Yes.
All right. Thanks, gentlemen.
Mm-hmm. Thank you.
Take care.
In addition to our Friday 5 p.m. broadcast on WGRN.org, Grassroot Ohio will now air on Sundays at 2 p.m. on WCRSFM.org, 92.7, 98.3 FM Columbus, and at 4 p.m. on WEJP LP 107.1 FM in Wheeling, Moundsville, West Virginia. You can also find us on SoundCloud, Apple Podcasts, Spotify, YouTube, Facebook, and Instagram. Thanks for joining us.